My name is Tasha Bunch, and I'm the Program Director here at the Institute for Intellectual Property and Social Justice. Thank you all for joining us for tonight's webinar, which is the first webinar in this school year's IP for the People Academy series. This series is a free, digital, open access academy designed for and marketed to creators, inventors, and entrepreneurs from communities of color who have historically and continually been locked out of receiving key knowledge and resources related to protecting and profiting from their ideas. In this series, we offer easy to digest and engaging talks on IP rights and navigating the IP system, highlighting tips and resources via live webinars, which are in right now, and these webinars are saved as an on-demand video series on our YouTube page. Please be sure to check out our website for information on future sessions. Tonight's webinar, USPTO provides trademark basics for entrepreneurs, features speakers and information from the U.S. Patent and Trademark Office. We are so grateful that you all are joining us tonight for our first session of this school year. First, we will have welcome remarks by the Deputy Undersecretary of Commerce for Intellectual Property and Deputy Director of the USPTO, Derrick Brent. After Deputy Director Brent, we will have a presentation by Jason Lott, Managing Attorney for Outreach and Trademarks, who will talk to us about what we need to know about trademarks when starting a new business. At the end of each presentation, we'll take some time to answer your questions, so go ahead and put them in the chat box as you think of them. We'll be monitoring throughout and we'll address your questions during the Q&A periods. And with that, now I'll turn the program over to Deputy Director Brent.
All right. Thank you very much, Tasha, for the introduction. And as I was mentioning just beforehand, it's very impressive. Tasha wears a couple of hats at least. She is, of course, a program director for the Institute for Intellectual Property and Social Justice, but she's also USPTO family as an interlocutory attorney with the Trademark Trial and Appeal Board. So Tasha, thank you very much for your service, and truly is special that again that you can wear two hats and that you also want to serve the community. And I also wanted to say thanks to my other USPTO colleagues who are on here today. As I said, we are family. And I want to say thanks to the IIPSJ for inviting us to participate tonight. Your mission is one shared by our agency, embracing the principles of equitable access, inclusion, and empowerment. So tonight we're going to talk about intellectual property, and in particular, we're going to talk about trademarks. Intellectual property is an important and valuable tool for small businesses, startups, and entrepreneurs. Patents cover inventions and can help a company break into the market with new innovative products. The smartphone, for example, contains thousands of patented inventions inside relating to computing, communications, or display. Copyrights protect expressions of ideas like music, books, or software. Trademarks, which will be discussed in more detail tonight, protect brands, names, or slogans associated with a business, service, or good. We all know those phrases, right? Just do it, American Airlines. Trademarks are one of the most important parts of intellectual property for small or early stage businesses. It is the first connection that you will have as a small business to the marketplace and to the customer. Your trademark is an announcement of your company, your product, your mission, your values. But a trademark, like other IP, is more than just a legal right that you own. It is an asset for your company that allows you to obtain financing from banks or raise money from investors. And IP is important to businesses. It's a fundamental cornerstone for businesses because IP helps to raise the value of companies. For example, there are studies and data that show that approval of a startup's first patent application increases employee growth by 36% in the first 5 years. A company's first patent can increase access to venture capital funding by 76% over the first 3 years. And a new company with a patent increases sales by 80% more than a company that does not own a patent. But we also, in the spirit of the IIPSJ mission, we want to build an inclusive ecosystem. We want to build an inclusive innovation ecosystem. And it's not just the right thing to do, it's the smart thing to do. And I'll give you a couple of quick stats that will show you that in multiples. There's data and a study and studies out there that show that if we increase the number of inventors to 4 times, if we just had 4 times more inventors in this country, we would increase the GDP of our country by 4.4%, or roughly $1 trillion. It's incredible. More inventors, and there are more inventors out there. There are. Innovation is not unique to companies. It is there. Everybody has some type of innovation in them. The director says that all the time. It is one of my favorite phrases. But I'm going to go a little deeper. And McKinsey organization did a study of African-American entrepreneurs and small businesses. And roughly 2% of African-American small businesses receive funding. And that's low. It's low. If you could just raise the number of African-American businesses up to the representative level in society, which is roughly between 12 to 14% to the demographic level, if you just raised them up, irrespective of performance, just raising them up, raise up the number of those businesses, $1 trillion to the economy and to the GDP. That is the mission, IIPSJ. It is the mission of the Department of Commerce. It's a mission of the United States Patent and Trademark Office, building a more inclusive innovation ecosystem. Bring more people to the table, much like our grandparents did when they would open that door and invite our friends in when we were kids. There's always room for one more at the table. There's always a little bit of extra for someone to eat. That's what we have to do with our system. And we do that because a more inclusive innovation system makes our economy strong, and that makes our country strong. So with that, I want to thank you again for allowing me to provide some opening remarks. And Tasha, I'm more than happy to take some questions if there are any.
Thank you so much for that, for those remarks, Deputy Director Brent. We really appreciate them. I don't see any questions yet in the chat. If anyone participating has any questions for Deputy Director Brent, please go ahead and put them in the chat now. If not, we'll go ahead and begin our next presentation. But again, please put questions in the chat as you all are thinking about them, so that you don't forget them at the end, and we'll make sure to get back to you. And I'm still not seeing any further questions.
Well, listen, thank you again. Thank you again for having me. And it is my privilege and honor to introduce not only a colleague, but my friend, Jason Lott, USPTO's Managing Attorney for Trademarks Customer Outreach. Jason, take it away.
Thank you so much, Deputy Director. Appreciate it. And thank you very much, Tasha, for the invitation to be here tonight. Thrilled to be here and thrilled to talk about trademarks. So I'm going to go ahead and dive right in. And as the Deputy Director said, and as Tasha said, if you have any questions, by all means, just pop them in there, and then we'll do our best to answer them before we have to get out of here tonight. So as the Deputy Director said, I'm Jason Lott. I'm the Managing Attorney for Trademarks Customer Outreach. And really what that means is it is my job to teach you about trademarks, what they are, why they're important, and how the federal registration of your trademark can help you build your business. This is kind of what we're going to talk about tonight. I know we have sort of a condensed time frame, so I'm not going to get to all of it necessarily, but I wanted to include everything in the deck, which I'm going to make sure that Tasha has a copy of so she can distribute it to you, to all the attendees, so you can look at it later on when you're like, wow, what was Jason talking about again? Oh, that's right. And you can look it up. So we're going to talk about what the world of trademark actually is, We're going to talk about why you might want to register that trademark with us, with the United States Patent and Trademark Office. We're going to spend some time talking about how to select or choose or create a strong trademark. If we have time, we're going to dip very briefly into filing and registration, and not because it's so easy, but because it can be pretty complex. And so we just want to hit some of the high level points, like how much does it cost and things like that. And also want you to make sure you have access to all of the amazing free resources that we have here at the USPTO. Really, as the Deputy Director said, what we want to do is make sure that you have an invitation into the ecosystem. And sometimes that means knowledge. Sometimes that means access to resources. Sometimes it means just opening eyes to something that is out there that you've kind of heard about before and sort of thought, oh, maybe I should get a trademark on that patent on my copyright or something like that. Well, that's what we are here to do. And we are here to make sure that you have that fundamental knowledge that you can use as you build your business. So let's talk about what in the world a trademark actually is. All right, so this is how I always like to start. All right, and there's a couple reasons I like to show this slide first. And the first is because these are probably logos that you have seen before, but you might not have seen them in black and white. Yeah, right. But I'm telling you, this is how these companies registered their logos with our office. And they did it for a very specific reason, which we're going to talk about here in a couple of minutes. All right. But I wanted you to put a little lantern right there. We're going to come back to that about why in the world are these things in black and white and not in color. But the main reason I want you to take a look at this slide is because I think it does a great job of helping cement in our brains what a trademark actually is. So if you look up in the top left there, you see the Apple logo. When you see that logo, what is it that you think of? Computers, right? Maybe mobile phones, maybe it's watches, maybe it's earbuds, maybe it's streaming services, right? But it's very specific goods and services when you see that logo. When you see Coca-Cola, what do you think of? Soft drinks. McDonald's, hamburgers. Microsoft, hardware, software. Samsung, consumer electronics. Amazon, buy anything you want and get it in 2 days. Google, search engine. Nike, shoes. Ford, trucks, right? So every single time you see or hear or experience that trademark, it is automatically calling to mind a very specific set of goods and services. And that relationship between the trademark itself and the underlying good or service is key. Without that relationship between the trademark and the goods and services that they represent, there is no trademark, right? Without that relationship, it's just a cool picture or a funny slogan. What a trademark has to do in order to be a trademark is indicate the source of specific goods and services, and perhaps distinguish them from the goods and services of another party. Easiest example to think of is the last time you went to a restaurant, waiter comes over, says, "Would you like something to drink?" And you say, "Yes, I would love a Coke." And he says, "Is a Pepsi okay?" Right? That is a trademark in action. You're using the Coca-Cola trademark to indicate the source of the goods you want. The waiter's using the Pepsi Cola trademark to indicate the source of the goods they actually provide. And both of those companies are using their trademarks to distinguish their products from their competitors. That's what you want to be able to do as a business owner. You want to have something that your customers use to identify you in the marketplace, and something that they use to distinguish you from your competitors, because you obviously are providing a superior product or service at a reasonable price. Right? So what you want to be able to do is provide legal protection for your brand. You know, a lot of times marketing folks will talk about a brand, and a brand is really kind of like how your customers feel about you, how they feel about your product or service. Well, it's really difficult to protect a feeling. So what you can protect instead is the trademark. It's the intellectual property, the thing that indicates the source of your goods and services. All right, so that's what a trademark is, right? Indicates the source of goods and services. Let's talk about what a trademark is not. Okay, a trademark does not mean that you legally own a word or a phrase. It does not mean that you can stop other people from saying that word or that phrase. And it certainly does not mean that people owe you money if they say that word or phrase. I've heard that before. "Jason, if I trademark this, that means anytime someone says it, they owe me a nickel." No, that is not what that means, okay? So let's think about Apple, for example, right? Apple is a registered trademark. Apple has registered it for their computers and mobile phones and all their other tech, right? Does that mean that Apple Inc. owns the word Apple? No, of course not. Does it mean they can stop me from saying the word Apple? No. Does it mean that I owe them money because I've said the word Apple? No. What it means is they have the exclusive right to use it to indicate the source of their specific goods and services, right? So it's not ownership in general, it's exclusive right to use for a very specific set of goods and services. All right, so here's the other thing I want to clear up real quick. So trademark indicates the source of goods and services. Sometimes people get it confused with a service mark. Really, what a service mark does is indicates the source of services. Yeah, pretty clear when you think about it that way. But here's the pro tip, okay? You don't ever have to worry about calling something a service mark. If you're providing goods, if you're providing services, doesn't matter. You can still call your thing, your brand name, your slogan, your logo, whatever you want, call it a trademark. And as you'll hear me say throughout the night tonight, mark. And that's totally fine too. So don't get too hung up on the difference between the two. You can just refer to them as trademarks. All right, so let's talk about some common source identifiers. These are the ones we typically think of when we think about trademarks. We're thinking about brand names, and we're thinking about slogans, and we're thinking about logos. All right, those are the big things that we're typically thinking about when we think about common indicators of source. All right, well, let me show you an example, okay? So down there in the bottom, you can see that is the federally registered trademark of Coca-Cola. Now, do you ever see Coca-Cola using their brand name in Times New Roman font? No, right? They got it in their Spencerian cursive font, right? But how you see it on the screen right now is how they registered it with us. And they registered it with our office that way for a very particular reason. They took advantage of something that is called submitting your drawing in standard character format. And what they're saying is, hey, USPTO, I want protection for the wording itself. Not what it looks like, but for the wording itself. Now, that might seem incredibly limiting, but it's actually incredibly expansive because it means over the life of the trademark registration, Coca-Cola can put their wording in whatever typeface, style, size, color they want to, and they're going to be okay, right? Because when they submit their evidence to us of how they're actually using it in interstate commerce, we're going to say, cool, Coca-Cola, because you registered it with us in the standard character format. Okay? Doesn't mean they have to use it in Times New Roman. We just have to put it in some typeface so we can put it on the registration certificate. But what they're doing is protecting the wording itself, not what it looks like. You too can do that. You can submit your brand name with us if you want to in the standard character format and give yourself this incredibly expansive flexibility for the protection of your wording. Same thing is true if you have a slogan, it's the real thing, always Coca-Cola, open happiness, just do it, fly the friendly skies, good, I'm loving it, right? Any of those sorts of things, right? We all know these sorts of advertising slogans. Yeah, that's something you could protect as well, so long as it is indicating the source of goods and services. And again, you don't have to protect what it looks like. You can protect the wording itself. Now, let me show the other thing that Coca-Cola has done. They have registered both of these logos with us, the Always Coca-Cola button and the two-dimensional Coca-Cola bottle. So can you register a logo? Yes. Yes, you can. Now, what you might be picking out here, because you're an eagle eye, you're like, Jason, those are in black and white. That's weird. It's like your very first slide. Why in the world are these trademarks in black and white and not in color? And again, here's the pro tip, okay? Coca-Cola registered their trademarks with us in black and white for a very specific reason. It's because they want flexibility over the life of their trademark registration to use their logos in whatever color they want to. So you do have an option to register a full color logo with us. That's cool. You can do that. However, what that means is you're saying, hey, USPTO, I want to protect my logo in these colors. I want to claim these colors in my trademark. I'm always essentially going to be using my trademark in these colors. And when I submit my evidence to you of how I'm actually using my trademark, you better believe it's going to be in those colors. But if we think about how business actually operates, and we think about how things change over the years, maybe you're not always going to want to use your logo in those very specific colors. Maybe you're going to want to have flexibility, right? Now, Coca-Cola is going to want to probably always protect stuff in red and, and white. Those are kind of their colors. But they might want flexibility to protect the green version of it, right? Or maybe they decide we're going to do everything in pink, or maybe we're going to do everything in orange or yellow, right? If they register their trademarks, their logos with us in black and white, it's giving them flexibility. So when they submit their evidence to us, we're not going to care what color it's in on their packaging or on their bottles or whatever it is. We'll say, cool, looks good, because they registered it with us in black and white. Now, I'm not allowed to give you legal advice. Tasha cannot, the deputy director cannot give you legal advice. No one at the USPTO can give you legal advice, okay? So what I'm saying, not legal advice. Well, what I can tell you is over 20 plus years of working with small business owners, invariably one of two things is going to happen. If you're a small business owner, you don't have a whole lot of money to put towards federal trademark registration, most of the time folks are doing one of two things. If it's the wording that they want to protect, they're going to register what you see on the left-hand side there in the standard character format. Protection for the wording itself, not what it looks like. But sometimes what it looks like really does matter. And so you want to have protection for what it looks like. And so you might submit the black and white version of your trademark to give yourself flexibility. Hey, look, if you're Coca-Cola, you're probably going to submit hundreds, if not thousands, of applications and have a bunch of registrations, including, Coca-Cola in its particular script font, but probably in black and white, maybe also in red. It really kind of depends. So that's kind of how it breaks down, all right? And these are the common sorts of things, right? Your brand names, your slogan, your logos. But before I move on, there's something I want to point out to you. There are these other non-traditional sorts of trademarks, because pretty much anything can be a source indicator, right? So long as it is indicating source, right? Pretty much anything could be a trademark if it indicates source. This is what I mean. It could be a sound, like the NBC chimes, bum, bum, bum. It might be the sound of the lion roaring at the beginning of an MGM/Amazon movie. It could be a color, like the color pink in fiberglass insulation. That's actually what the little image is on the bottom left-hand side there. That's one of the first registered trademarks for a color, and it's the use of pink on fiberglass insulation. Now, does that mean that Owens Corning owns the color pink? No, of course not. But they are the ones who have the exclusive right to use it to indicate the source of fiberglass insulation. If you look out the window, you might see a brown panel truck parked on the street and somebody hopping out in a brown uniform delivering your packages. You probably know who that is just looking at the color on the vehicle. You know it's UPS, right? And UPS has registered the color brown when used on their trucks and on their uniforms to indicate the source of their parcel delivery services. It could be something like a shape. If you look in the bottom right-hand corner of the screen there, you can see the shape of that bottle. I don't even have to ask. You probably already know, yeah, that's Coca-Cola, right? So the shape of the bottle is enough in your brains to indicate the source of their soft drinks. You don't even have to see a brand name on it. Think about the shape of a Weber grill or the shape of a Volkswagen Beetle. You see it, you automatically know who the manufacturer or provider of that thing is. Now, I'm not saying you have to have any of these things, okay? As a business owner, do you have to have a color registered? No, of course not. But I want you to think creatively about how you're using your trademarks to indicate the source of your goods and services. Maybe a very distinctive packaging or a distinctive combination of colors that you use on your packaging, right? So as long as it's something that is indicating source, it has the potential to be registered as a trademark. All right, I'm going to give you a couple real quick knowledge check here. Okay, and you don't have to shout out your answer. I'm going to give you the answer. Okay, so you can keep it to yourself, and of course you're going to be 100% correct. Gold star, A plus. All right. So does a federally registered trademark mean that you own a word or phrase? No. Doesn't mean they own it. It only means that you have the exclusive right to use it to indicate the source of your goods and services. Great job. You're getting an A plus so far. Okay. What about this one? Now, this one's a little tricky because we haven't talked about this. Do you have to use your business name as your trademark? Yeah, I'm going to give you a chance to think about that one. The answer here is no, you don't. The business name is just what you register with your state or jurisdiction to do business there. It is not necessarily your trademark. You could have something super boring that you register with the Secretary of State of your state to do business in that state, but have something that's really amazing that you use with your customers to indicate the source of your specific goods and services. So, could your business name also be your trademark? Sure. Yes, absolutely, it could be. Does it have to be? No. Here's an opportunity for you to use some creativity in terms of how you're communicating with your customers. All right. So that's the fundamentals of trademarks. Let me check in real quick with Tasha here. Are there any questions that have come in the meantime that we can clear up before we jump into benefits?
No questions so far, Jason. You can go ahead and,
Keep
and
rolling.
keep going.
Okay, sounds good. All right, folks. Well, let's talk about some of the benefits of federal registration. So, here in the United States, trademark rights are created in a couple of different ways. We're going to talk about two of those ways right now. One is common law, and the other is federal registration. And if those words seem a little weird to you, don't worry. I'm going to break it down for you. All right. So, in terms of common law trademark rights, these are the quickest and the easiest. These are created as soon as you begin to use something in commerce to indicate the source of your specific goods and services. That's because in the United States, trademark rights are based on use, which is great. You start using something, you're building up your trademark rights in it. Now, the drawback is it's going to be limited to the geographic area in which you are operating. So it might be based upon the law in Virginia or Maryland or Washington, D.C. or California or Oklahoma or Texas or Indiana, whatever, or Illinois, wherever it is that you happen to be from and happen to be working from. Okay. So it's going to be based upon those state law that's there. Now, some of you might be thinking, Jason, haven't you heard of the internet, right? I do all my stuff online. Well, at that point, hey, maybe your rights are all over the place. But for the purposes of an illustration, let's assume that you're operating in a real small town. You're not on social media. You're not doing anything online. You're just working doing your booth at a farmer's market. Okay, you make artisanal pickles and you take them to your local farmer's market and you're selling them there, and they're so popular that people come from the surrounding counties just to buy your artisanal pickles. Okay, well, cool, that's fine. You know what I mean? You can use your trademark rights and you could have your kind of protection in that area. But what if you want to grow your business? What if you don't want to just be operating in a small little area and you want to have protection across the country or maybe later on internationally? Well, you might want to think about federal registration. But if you're just starting out, that's okay, right? You can go ahead and use a little TM symbol, use a little SM symbol, put people on notice. Hey, this is my trademark. Okay, don't mess with my trademark, right? And you could do that right now if you wanted to. Put a little TM next to your trademark. TM stands for trademark, SM stands for service mark. There's nobody who has to give you permission to put it next to your trademark. There's no particular font you have to use, no size, no particular placement. A lot of times people put it on the right-hand side in either a superscript or maybe in a subscript, but it's really up to you. The one thing that you cannot do, however, is use the R in the circle symbol. That is reserved for trademarks that are federally registered with our office. All right, so here's the deal. You could go your entire business life and just rely on common law trademark rights. You never, ever, ever have to register with our office. It is your choice. It is up to you as the business owner. And you might decide, hey, I'm good with my common law rights. I'm cool. Forget about it. Jason, go away. Okay, yeah, I get it. Okay. But it might be that you do want to have nationwide protection because you are going to be growing your business. You're going to become the premier artisanal pickle provider for the entire United States. Okay. Well, you might want to have protection across the United States. And you can get that through federal registration. So these rights are created when you register your trademark with us. It creates a legal presumption that you are the owner of the trademark and that you have the right to use it throughout the entire United States and its territories. That is not true under common law. There is no legal presumption created there that you are the owner and have the right to use it. Instead, it's going to be up to you to prove it to the judge or the jury or whoever, right? Here, you can be like, no, judge, check this out. I have a registration right here, presumptive that I'm the owner, have the right to use it. And the judge says, cool, great. All right. You're also putting the public on constructive notice that you're the owner of the trademark. You can bring legal action concerning your trademark in federal court. Not true under common law. There, you're going to be suing in state court. This is a really great benefit that not a whole lot of people know about. So, pro tip, you can record your federal trademark registration with US Customs and Border Protection. So once you register with us, you can say, hey, CBP, I've federally registered my trademark. I would now like to record that with you. And CBP says, cool, thank you very much. And this is going to be a great benefit for any of you who happen to be in an industry where there's lots of counterfeit goods coming into the country. Right? Think apparel, footwear, software, hardware, aftermarket automobile parts. I've heard wine is being counterfeited, pharmaceuticals, personal protective equipment there for a while. Pretty much anything you can think about, there might be counterfeit goods trying to come into our country. So what you can do is you can say, hey, CBP, I would like to record this with you. And the agents say, awesome, thank you so much. And then they're working at the ports and borders to stop those counterfeit goods from entering in the country. Because, hey, look, maybe there's a big push for artisanal pickles, okay? And they're going to be coming in from other countries and you want to keep them out, all right? Another great benefit is that you can use your application or registration to try and extend your protection abroad. Because trademark rights are territorial. There's no one place you can go and suddenly have trademark registration around planet Earth. That does not exist. Okay, so if you want trademark rights in a particular country, you need to file there. And so this process that we have in place, this agreement that we have in place with other countries around the world says essentially, I want to extend protection from the United States into this country and into this one and into this one and into this one. All right. Now you're still going to be paying fees and you're going to be essentially filing national applications and things like that. But the whole point of it is to streamline the process to make it a bit more efficient for you. You have an opportunity to take advantage of that if you apply or register with us. And of course, you no longer need to use the TM or the SM. Instead, you replace it with an R in the circle, kind of the gold standard when it comes to federal trademark registration. All right, let me hit a knowledge check here. You guys are doing great already. You've got 2 out of 2 right. So let's see what happens when we ask you this one. Are you required to register your trademark with the USPTO? Yeah, we just talked about this. And the answer is, of course, no. You do not have to register with us. It is up to you. It is your choice as the business owner. Now, a lot of times people do, and as the deputy director was talking about earlier today, there's a lot of value that is created by protecting your intellectual property. Look, there are some stats out there that say that the Apple brand itself is worth $800 billion. You know, some people might put it at 400 billion, 200 billion, take your pick. Okay, that's a lot of billions of dollars for just the value of the brand alone. And a lot of that has to do with the fact that they are registered with our office. So do you have to? No, but you can if you want to. And a lot of times businesses do take that extra step. All right, you know the answer to this one. Does registering your trademark with the USPTO give you international protection? And of course, the answer is no, it does not. Registering your trademark with us only gives you protection in the United States, or rights within the United States and its territories. So I'm not seeing your answers, but I know you're getting them all right. So, okay, that's 4 out of 4 for all of you, still getting 100%. All right. Well, I'm looking at the clock right now, and I see we still have a little bit of time. So, Tasha, let's see. Any questions? If not, I can hit some tips for how to select or choose a strong trademark.
Jason, we do have one question, and it went with the what you just talked about. So I'll ask you now. One of our audience members asked, should someone get a federal trademark registration if they have an online business or a YouTube channel business?
Ooh, that's a great question. Well, first of all, I will say thank you for asking the question. Before I answer, one thing I'll say is we're never going to be able to tell you should you do something, okay? Just because that could tread into legal advice. But I'm going to hear that as can I, okay? So can you potentially register a trademark for your internet business or something you're doing on social media? The answer is yes, so long as you are providing a specific good or specific service, right? So if we think about online retail stores, those are online businesses, right? You can register, Nike is going to register Nike as a brand name for online retail store services featuring clothing and footwear, right? You might have an Etsy shop where you're selling your artisanal pickles, okay? And so, yeah, you could register your brand name for what you use for your online retail store that's on Etsy that features your artisanal pickles, okay? If you're doing something online through social media, it gets a little bit trickier there because sometimes people are just using a social media handle as a handle. They're not actually using it to indicate the source of specific goods and services. So if what you're using on social media is actually functioning as a brand name, then that's a possibility right there. You know, whether it's your artisanal pickles, or maybe it's the fact that you're creating these videos that show people how you create artisanal pickles, you know, so it's some sort of, entertainment or educational sort of service, because it's these videos, online non-downloadable videos featuring pickle production process or something like that. I don't know. So it's possible, yes, and that's a really great question. But always remember, it depends on, are you providing a specific type of good or service? That's what it really boils down to. Any follow up to that, Tasha?
Thanks, Jason. No follow-up, so feel free to keep going.
All right. Well, let me roll into this, okay? Because hopefully this is where you're going to get a whole lot of great information, especially for those of you just starting out into business. Okay. So we're going to talk about how to select or choose or create a strong trademark. A couple things to remember here. It's our mission as the USPTO to register trademarks. We want to register your trademark. Okay. However, not every trademark is registrable. There are reasons why trademarks are sometimes refused registration. There's a whole examination process that takes place once you apply to register. It gets assigned to an examining attorney. That's the job that I had when I first started. It's the job I'm pretty sure Tasha had when she first started. And we would examine your application to determine whether or not it was eligible for registration. So keep in mind, not everything's going to register. And here is the part that kind of like flipped my mind a little bit when I first realized it, that even if you get that registration, it might not be enforceable, which is really weird to think about because you spent all this time and effort to register your trademark. Are you telling me, Jason, that I cannot enforce it? And the answer is sometimes is yes, because of those common law trademark rights that are out there. Because remember, there's no rule that says you have to register. So it's possible someone's been out there for 100 years using a trademark and they don't get around to registering it, but they have stronger rights than you do because of those common law rights. So that's why it's so important before you get your business going, or as you're getting your business going, you're making sure that your trademark is both federally registrable and legally protectable. So I'm going to hit two main concepts right now, which are hopefully going to help with those things. And they're also the two main reasons why trademarks are refused registration at our office. All right. So if you can avoid these, you're taking pretty big steps towards getting to registration. It's not a guarantee, but there are good reasons that you might be able to make your way. Okay. So one thing you want to avoid is what's called a likelihood of confusion refusal. And the other is what's called a descriptiveness refusal. Let me dig in to both of these concepts, okay? So let's talk about likelihood of confusion first. So if we think about what a trademark does, it indicates the source of goods and services. All right. So if something is confusing consumers, it's not really doing what it's supposed to do of indicating the source of goods and services. It's confusing people. So we want to avoid that situation. And so our office will refuse registration of trademarks which have the likelihood of confusing consumers if both of them were to coexist on our register. All right. So there's a test that the examining attorney is going to run when she encounters your application. All right. She's gonna, it's a little bit more complex than this, but it really boils down to two things. Okay. She's gonna ask the question, is your trademark similar to what she found in the database? See, it's similar, right? It's not identical. They just have to be similar. Do they sound alike? Or do they look alike? Or have a similar meaning? Or maybe a similar commercial impression? Doesn't have to be all of those. It could just be one. So if that's true, if those trademarks are similar, she's going to ask the question, are the goods and services provided under each of these trademarks related? Now, again, this is not, are they different? It's, are they related? Maybe they're goods that are complementary. Peanut butter and jelly, right? Smucker's still has a registered trademark for a jar of peanut butter and jelly, okay? Yeah, they're often used together. They're often going to be provided by a company under one brand, right? So that's really what it boils down to. Do we as consumers, are we used to one company typically providing both types of goods under the same trademark? Does one company typically provide both of these services under the same service mark? If so, they're probably going to be related. Now, it's a little bit of a fuzzy concept. It's not a bright line rule. There's no if this, then this. So the work that the examining attorney is going to be doing is weighing both of these two prongs of the test in addition to several other things. All right, that's a little bit, what does that really mean, Jason? So let's put it through a hypothetical to make sure we can understand it, okay? So let's say that we decided as a group, we were going to register T Markey as a brand name for shirts. And we apply to register. The examining attorney gets the case. She looks in the USPTO database and she discovers, someone has already registered T Markey as a brand name for pants. Is this going to be a problem for us? Well, we do the analysis. Is T Markey similar to T Markey? Yes. It's actually identical. Doesn't have to be, but it is. And so then we ask the question, are shirts related to pants? And the answer is yes. There's going to be plenty of evidence that companies that make shirts also make pants. They all have them under the same brand name. And so in this case, there's going to be a likelihood of confusion and our application would be refused. Okay, well, let's change that hypothetical. Let's say that we apply to register T Markey as a brand name for shirts. Examining attorney finds T Markey as a brand name for pants. Is this a problem? Well, again, we do the analysis. Is T Markey similar to T Markey? Yeah. It's not identical, but they are similar. They sound alike. T Markey. Which one did I say? Who knows, right? And so we already know shirts are related to pants, so therefore a refusal of our application. Let me change it one more time for you. We apply to register T Markey as a brand name for shirts. Examining attorney finds T Markey as a brand name for golf flags. Is this going to be a problem? Yeah, well, we do the analysis. T Markey similar to T Markey? Yes. Are shirts related to golf flags? Actually, I don't know. I would have to do some research in order to find out if they're related. And so this is what we would be doing as applicants before we file, is we would look for this sort of evidence ourselves. Does one company use the same brand name for their shirts and golf flags? I mean, does one company make both of those things? Or does one company make both golf flags and shirts? I don't know. We'd have to do some research to find out. And that's exactly what the examining attorney would do. So in this case, probably not going to be refused because there's probably not a whole lot of evidence out there that companies are doing both. But again, it's going to boil down to the facts in the case. And this is why it's so important that before you file, you do what's called a clearance search. You clear the area around your trademark to make sure there's no one else out there using a same or similar trademark for related goods and services. And we always recommend you do this on your own using our database. of federally applied for registered trademarks. It's free. You can dive in there. You can do a search in there and see what else happens to be on the register or applied for at that point. And of course, we also recommend that you do some common law searching. Just pop the trademark into Google or Bing or Yahoo or DuckDuckGo or whatever it is that you use and look to see, is somebody else out there using a same or similar trademark for related goods and services? That might not stop. It might not be a problem here for federal registration, but you better believe it could be a problem later on for enforcing your registration. You want to know about it. If all that seems like too much, you might want to think about hiring a private trademark attorney to help you conduct that comprehensive clearance search, because she's going to be looking in a whole bunch of places, okay? Not just our database, but all sorts of other databases, looking online, resources I can't even think of. And so sometimes it's helpful to have a professional that you have hired do this search for you. And when I say that, I'm talking about a US licensed attorney who will do that search and help you with the analysis of likelihood of confusion. I understand attorneys can be expensive. If you see the link down there at the bottom of the screen, you'll see on that page, there's some links to some resources for free and reduced price legal services as well. So just because you can't afford the highest price attorney, don't worry, you're not left out. There are some resources that are available for folks who need a little help. Okay, so real quick knowledge check here. So let's see if you get this one right. Let's say that we decided we were going to register X-Seed as a brand name for our agricultural seeds. But we remembered, oh, that's right, I attended this webinar about likelihood of confusion. Let me look in the database. And so we look in the database and we discover, uh-oh, someone has already registered X-Seed as a brand name for live plants. Is this going to be a problem for us? Is X-Seed similar to X-Seed? Yes. Are agricultural seeds related to live plants? Yeah. I typically say this is an opportunity for you to do more research, but I actually talked to the attorney who argued this case, and he said, yeah, the Trademark Trial and Appeal Board decided that they are related. So I feel a bit more confident in saying, yes, seeds are related to live plants. So if this was us, we would probably want to rethink it. We might want to come up with a new brand name for our agricultural seeds that we might stand a chance of being able to protect at the office. All right, Tasha, I see we have about 12 minutes left before we have to get out of here. Any questions about likelihood of confusion?
We do have one question from Christine again. She's full of great questions tonight. So she said, what if my company is called Resume by Christine and someone has Resume by Jennifer? Will I get a likelihood of confusion if we're registered for the same goods?
Oh, that's a great question. So love the question, Christine. So remember, we cannot provide legal advice, so I can't give you a definitive answer, but let's think about that analysis, okay? So if it's resumes by Christine and resumes by Jennifer, I think is what it was, are those similar? Are customers, are your consumers do they sound alike or look alike, have a similar meaning, a similar commercial impression? If we think about the strongest parts of the trademark, probably going to be the names, Christine, Jennifer. Are those similar? Do they sound alike? Right? Do they have a similar meaning? Right? So you can do the analysis for yourself about whether or not that's something that would cause some confusion. Because we know already, as you have indicated in the hypothetical, yeah, these services are going to be the same, right? And so really it boils down to, are the trademarks themselves similar? And the great news is, if they are not similar, then they can coexist on the register. And this goes to a larger point, and I love the question. Look, if the answer to both of these, to one of these questions is no, no problem. Because if we think about trademarks that, like, let's say, for example, the trademark Dove. When I say Dove, what do you think of? Right? Some of you probably think of soap, some of you think of chocolate, some of you think of ice cream, right? And it's okay that Dove is registered for soap and for chocolate, because we as consumers are not going to be confused, right? So can a similar trademark coexist in a marketplace with other people? Yes, so long as the goods and services are unrelated. And the flip side of that is, even if those goods and services are identical, can that coexist? Yes, so long as the trademarks are dissimilar. So hopefully that helps you sort of talking around the issue, because I cannot give you a specific answer. Hope that's okay.
Jason, I think it was helpful. Christine responded, now I realize they do not sound alike. And so, Christine, thank you
Okay.
for taking us through that additional knowledge check. I'm sure that helped everyone listening in tonight.
Absolutely. Anything else, or you want me to jump into strength of the trademark here? I can probably cover this in about 5 minutes, and we can close out with about 5 minutes of questions.
Sounds perfect. Go right ahead.
Cool. All right. So here's the deal. Okay. So if we think about what a trademark does, it indicates the source of goods and services. So if something is not indicating the source, it's not functioning as a trademark. And sometimes that's because the trademark itself is just describing what the goods or services are. Okay, so if it's just describing, it's not indicating source, it's not functioning as a trademark, it's going to be refused registration. Right? Let me show you what I mean. Okay, so there's something called the descriptiveness spectrum, but I like to think about it as a temperature gauge that goes weak to strong or cold to hot. You want to be in the hot range. You want your trademark to be fanciful or arbitrary or suggestive. All right, let me show you what I mean by all these things. So down at the bottom in the cold area is generic wording. It's just the common everyday name for the good or service. It is not registrable at our office. An example would be milk as a brand name for a dairy-based beverage. Right? Does milk indicate source of a dairy-based beverage? No, it describes something that is of what the beverage actually is. It's milk, right? Or it's a key component of the beverage. So you're never going to be able to register a generic name of the thing. Okay? So as we move up our temperature gauge, slightly better than that are trademarks that describe something about the good or service. All right. And these technically are unregisterable at our office on what's called the principal register. Now, I know that's the first time I've said those words here tonight. So some of you are like, hey, what does that mean? Essentially, think about it this way. The principal register is what you want to be on. It's the one that gives you access to all of those sweet, sweet benefits I was talking about earlier. There's another register called the supplemental register, and that's for trademarks that are like kind of capable of functioning as trademarks, but they're not really there yet. You don't have access to all of those great benefits when you're on the supplemental register. So the principal is where you want to be. And if your mark is descriptive, it is going to be refused registration on the principal register unless it now has acquired distinctiveness. Okay, you see the difference? So if it's just describing something, it's not really functioning. But if in the minds of consumers, it's now distinctive and it does indicate source when people see it, well, there it's elevated itself up and it is something that's registrable. Here's an example, creamy whip for whip topping. If we think about creamy whip, it's describing whip topping that is creamy, right? It's going to get refused. But in this case, they said, well, okay, yeah, maybe. However, this wording has now acquired distinctiveness in the minds of consumers. And so when they see it, boom, they think of us. And we said, okay, you can register. Now, here's the deal, however, you can get registration, but the scope of your protection might be pretty small. Right? Because it's descriptive, it's just barely on there. There's probably going to be a lot of your competitors who kind of have similar wording. It's cream and whip. It's whipping the cream and it's whipping and creaming or whatever. I don't know. Right. And so they're all like kind of the same. And I don't know what this is. Right. And so it's going to be very difficult for your customers to distinguish you. The way I think about it is this. We've all seen a ball pit. Right. So this is the ball pit of trademarks, and all these like trademark things, they're all kind of similar. Very hard for your customer to pull you out of that ball pit. However, what if you moved up the temperature gauge and your trademark was actually suggestive? So it suggests something about a good or service, but doesn't exactly describe it. These are registrable at our office. An example would be copper tone for suntan lotion. Right, so it doesn't describe suntan lotion. It tells you or suggests that if you use the suntan lotion, you put it on your skin, you go out into the sun, your skin might take on a coppery tone. It's suggesting something. So in the ball pit of trademarks, I got a little bit more scope of protection here, right? It's going to be easier for your customers to pick you out of that ball pit of trademarks. But even better than that, as we move up the scale, are going to be fanciful and arbitrary trademarks. Fanciful trademarks are made-up words. They have no meaning in English or in any other language. They are registrable at our office. Xerox would be an example for photocopiers. Kodak for cameras, Kleenex for facial tissues, Pepsi for soft drinks, made up words. Now, we as consumers know what they mean. When we see them, we automatically think of that particular company or that particular product. But they're actually just made up words, and they are very strong. In our ball pit of trademarks, very easy for customers to pull you out of the bin. Also good are going to be arbitrary trademarks. These are words that have meaning, but that meaning has no relationship to the underlying good or service. Again, registrable, an example would be Apple for computers. It is a known word. It's a common everyday word, but it's arbitrarily applied to computers. It means nothing except for meaning as a trademark. So again, in terms of scope of protection, pretty big. And here's the deal too, folks. When you've got this big scope of protection, it's going to help you in this likelihood of confusion analysis. Because if you have some made up word or some arbitrary trademark, what are the odds that your competitors are also going to have something like that? Probably pretty slim. And when they say, oh, wow, that's a cool trademark, I'm going to try and register something similar. Guess what? The examining attorney assigned to the case is going to see your trademark in the database. And when your competitor comes in, they're going to say, no, likelihood of confusion, right? So there's a lot of value that is created by having a strong trademark, something that is fanciful and arbitrary. One real quick knowledge check here before I answer a couple of questions, if there are any more. So which one of these would be registrable? Bicycle as a brand name for bicycles, or bicycle as a brand name for playing cards? Yeah, you get it. You know the one on the right there. Bicycle is a brand name for playing cards. It's arbitrary when applied to those particular goods. And so therefore it would be protectable. And it's been around for over 100 years, a registration of the US Playing Card Company. All right, so I see we're 3 minutes out. If we have time, I can briefly answer any questions about filing and registration or anything else that you want to talk about. But again, I'm going to make sure Tasha has a copy of the deck and she can distribute it so you can see all the things that we didn't get a chance to cover today. So what do we have, Tasha? Anything else?
Thank you so much, Jason. Christine has one more question. She asked, so resume by Christine would be considered a suggestive trademark, right? And Christine, I'll just ask you if you can say what your goods or services would be, because that would help to determine whether or not it would be a suggestive trademark, right? Sorry, Jason, to jump in on your territory there.
Oh, no, not at all. We talk about, Tasha, you know this stuff. And I love that you asked the question, because that's the thing to remember always, folks. Tasha is absolutely right. In order to make determinations, whether it's likelihood of confusion, whether it's descriptiveness, geographic descriptiveness, whatever it happens to be, it's always going to boil down to what are the goods and services that are provided under that trademark, right? So if we think about our Apple trademark, what if it was Apple as a brand name for apples? No good, right? Because it's generic. Apple as a brand name for computers, hey, that works. So resumes by Christine as a brand name for gardening gloves and shovels, hey, you know what I mean? That might be arbitrary at that point, right? So it's always going to depend on what your services are.
And she followed up and said it would deal with resumes as well as educational stuff for employment. What are your thoughts there, Jason?
Yeah, all right. So you know, Christine, we cannot give you legal advice here, right? So you know we can't tell you whether or not that's registrable. We're not allowed to opine on the registrability of a trademark. So we can't exactly say, but it sounds to me like you were doing the sort of analysis that a good business owner is going to do and try and figure out, would this be registrable? Would it be descriptive or not? So it sounds like you think it's suggestive. Cool, great. I'm not allowed to say one way or another. One thing I do want to point out, however, and you might have this conversation with the examining attorney who gets assigned to your case. The examining attorney might say, hey, cool, Christine, this is great. Maybe I also think it's suggestive and therefore you could move forward. But there might be one thing that the examining attorney would point out, and is that if there is descriptive or generic wording or non-source indicating in a trademark, the examining attorney might ask you to what's called disclaim wording that is in the trademark. And what we mean by a disclaimer means that you're just not claiming exclusive right to it. It means that other people can also use that wording in their trademark. So it adds a little sentence onto your certificate that, no claim is made to this wording apart from the mark as shown, something like that. Now, I'm not saying that is going to happen, Christine. I'm just saying it's something I want you to be aware of It always depends upon the circumstance, and it might be something the examining attorney asks about. But again, that's the sort of thing that happens all the time, anytime there's wording in there that's non-source indicating. If we think about, for example, let's say Apple wanted to register Apple Inc. as their brand name. Well, the examining attorney might say, well, Inc. for incorporated is non-source indicating, therefore it must be, quote, disclaimed. Again, it stays in the trademark. It just means that other incorporated companies can use the word Inc. in their trademarks as well. So love the questions, Christine. Thank you for participating. And I'm sure you got all of the knowledge checks right. Okay. I don't know if you put anything in the Q&A, but I know you actually got them right.
Yes, thank you so much, Christine, and to everyone for listening tonight. And I'll take the last question, which is, will there be a video recording posted? Yes, it will be posted on our YouTube page, and I will send out the link to you all when the recording is ready, in addition to a link to access Jason's slides from tonight. Thank you, Jason, Deputy Director Brent, and the entire team at the USPTO for providing our first guest lecture for the IP for the People webinar series, provided by the Institute for Intellectual Property and Social Justice. Just to let you all know, next Wednesday at 7 p.m., we'll have our next session, which is if you already have, an idea for a business, but you need to figure out how to get started. For example, what type of organization should you form? A partnership, a limited liability company? Where should you register your organization? Who and how should you fund starting up your business? And then what are the rules that you need to follow once you decide what type of business you want to form? If any of those questions are top of mind for you, I hope you will join us next Wednesday night at 7 p.m. for our next webinar in this series. Again, thank you to you all, and I hope you all have a wonderful evening.